Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We are answering a question from YouTube user El Doroderd 9026. So El Doroderd, the EEO asked us, the EEOC interviewed my former employer last week, and they told me that my former employer and their attorney left the office mad. What's that mean for my does that mean my case is going in my favor? Can I send a demand letter on my own? Okay. So, three answers. One, don't put too much stock in anything anyone at the EEOC says in terms of like characterizing something. Like, I've heard a lot of like, they left mad. Listen, I've heard that from a lot of EEOC mediators being like, they're steaming mad over there. Okay, well, I know Babo, the attorney over there, and I'll probably just go talk to him about this if he's angry. And the EEOC employee is like, no, he's too angry. Yeah, Bob owes me a scotch. I think we're fine. You go talk to Babo, the defense attorney, the hypothetical defense attorney, and Babo's like, yeah, so I mean, we're looking to get this done. Like, I think your client's a little high, but like, yeah, we do want to pay something here. What's the story? And I'm like, oh, mediator's telling me you're spicy over here. Like, you're raging out. And Babo, the defense attorney's like, yo, my client, he's doing a deal on his laptop and he doesn't even really know what's going on right now. Like, I don't think he's spoken to the mediator. And he's just confused as to why he's here. I'm like, yeah, that sounds about right. Okay, so like, let's just hash this out in this conference room and like let that mediator go eat his or her lunch, right? Like, so I would be a little skeptical as to the characterization that, defense counsel left angry. Be fairly rare for defense counsel to care. It's hard. How angry can you be when you're making $1,500 an hour to sit and chat, right? Like, how angry can you be at $1,500 an hour? Unless, of course, you're specifically being paid to be angry, but that wouldn't make sense in this context. So I suspect defense counsel was fine. Listen, could the employer be angry? That happens. That certainly happens. There's a lot of employers who get very angry, and it's always generally speaking, it's a very good thing when the employer gets angry during a fact-finding conference or something like that. So that could be positive. Does it mean the case is going in your favor? It absolutely could. If it's true that they left angry, it could mean the EEOC was giving them the business and like laying the hits out, and it was a whole thing going on. That could be positive for you. But the reason, and I'm saying it could be because like, I don't know a lot of what's going on. I don't know anything about your claim. I don't know what these people were being asked. I don't know what they actually said to the EEOC investigator. I know so very little that I can't really tell you if it is good news or not, but it could be. But the reason I picked your question was because your last query here, can I send a demand letter on my own? Yeah, you absolutely can. You can also, while you're in the EEOC and you're pro se, you can go to the investigator or mediator, whoever it is you're dealing with, and say, hey, I would like to get a demand to the other side. And they can carry that demand for you. In fact, they will likely be thrilled to do so. Generally, if they can get cases settled, that is better for them. That means they do less work overall. They're happy with that result. It also lets them feel like they helped someone, which I think many of them do like to feel. It's not that they want to harm people actively. It's just that, they're overwhelmed and perhaps under enthusiastic about their job duties, right? So it's not that they don't want to help. And I think if you carry demand, that is often something where an investigator, certainly a mediator, will jump on that with a little bit of vim and vigor and like carry that demand to the other side and be like, let's start a conversation about getting this case settled. And that's positive. So you absolutely should and can extend a demand. I might, if you're in the EEOC, I might do that through the investigator if you're pro se. If you're represented, your attorney should handle that always, 100% of the time. But I just want to answer that part of the question, because getting a demand in is an important part of all this. Like, you have to know what you want and have some plan for conveying that and pursuing that. Otherwise, what are we doing? Okay, what's the purpose of all this if it's not to reach your goals, to make you whole for what was done to you, right? I hope this is helpful. If it was, like, subscribe, comment down below. It helps me to help more people just like you. And remember, almost everybody works. Not everybody wins. Be smart out there.